Right. All right. Good evening. Good evening. This series has been great. First week went well. This week we have some more powerhouses, starting out with our guest that's coming up. So it's a lot of things going on right now, a lot of moving parts. So some of us are starting our businesses, some of us are growing our businesses, and some of us are assessing our businesses in this season. So um, this segment today, I'm going to bring on our guest, attorney Michelle J. Miller. I met her this year, and she is a powerhouse to say the least. And she will be talking to us about how to protect your business so that you won't have any headaches later. So it's a lot of us, we deal, the last thing we think about is trademarks and copyrights and all of those things. We just package up these nice products and sell them. And then next thing we know, someone else has ran off with our stuff and we can't do anything about it because we didn't protect it. So I have the awesome Michelle J. Miller, attorney Michelle J. Miller. I say she can prophesy and then help you protect your business all in one sitting. So, Michelle, can you hear me?
Can you hear me?
Okay. Yes, I can. Good.
Okay, I'm having some problems with my video. So
Okay.
I tried through 2 different platforms, and for some reason, for the
Okay.
time, I can't get on video, and for some reason, I can't seem to log in from my iPhone.
And it's still not working.
No, for some reason, my iPhone, I have a blank screen when I try to join. It looks like it's thinking about letting me, but not quite.
Well, we can still hear you, so that's all that matters. They have your picture is right behind me. Is it right behind me?
It's behind.
Yep, right behind me. So she's right there. If
Yeah,
you
no, I'll
don't
try
see her,
to.
there she is. So we're
Right.
going to just get started. I will let Michelle introduce herself and we can take it from there. I don't want to waste any time with a long introduction. I will just let you get at it and get rolling. Go ahead, Michelle.
Well, what can I say? My name is Michelle Miller. I am the proprietor and owner of the Michelle J. Miller Law Firm that is located downtown Chicago. I help people protect their business, their brand, and their content. I also help people with various contract issues in media and entertainment. So anywhere from book contracts to a TV production. So primarily what I do, even though I'm here in Illinois, I work with people across the US. I also have the ability to work with people across the seas, especially in the issue of trademarks. But also, in addition to my law degree, I have an advanced law degree in international business law. So just to let you all know the number of different types of clients that I can work with and what I have worked with. So, I mean, Alicia, do you have questions? Do you just want me to dive in? Like, tell me how.
Definitely dive in. We're starting with like the ABCs of protecting your business. So you tell
Okay.
us what that looks like what should we start with and how do we take it from there?
Well, I think what I want to do, especially in talking about this topic, I'm going to break it up into 3 areas, but I'm going to focus on one today.
Okay.
So when I say focus on 3 areas, when you're considering your business, when you're considering your brand, there are 3 areas you definitely need to consider and that you also need to pay close attention to. One, the appropriate contracts for your business. A key way that you protect your business is to have the appropriate contracts in place. I'm surprised by the number of people who I talk to, who I've learned they're on the buddy system, the hand clap system, on every kind of system except for a contract. And many times things are well attended when you start off, but things happen. And sometimes when things happen, how do you determine the issues that need to be resolved? And if you do not have a contract in place, resolving those issues can be very difficult. And so the first thing I would tell people, make sure that you have your contracts in place. I won't talk about the various contract work that I do, but when we're talking about business protection, that's number one. And don't be nervous about asking someone to sign a contract. Do not be nervous to spell out everything that you need to spell out in order to get things done. That's extremely important. And sometimes when people are not willing to have a conversation with you and memorialize how things will go in this business relationship, it could potentially be a red flag for you to consider, is this somebody that I should be doing business with in the first place? Second issue that need to be considered, and this is an area I'm going to talk about, is in the area of intellectual property. I want to go into that a little deeper. And the third area, which I'll talk a little bit in intellectual property, I want to focus today more on the area of trademark. The third area of where you protect your business is by using a confidentiality agreement, and what you are protecting is your trade secrets. So trade secrets fall under the area of intellectual property, but again, there's a lot of people that don't even know what trade secrets are. They don't know how to identify them, so they definitely don't know how to protect them. So that's an area that's really important throughout your business. When you have a trade secret, that's the information, your secret sauce that keeps your business running. And the thing that you want to make sure is that you have entrusted people that have your secret information that's key to your business, and that they keep that information confidential and they don't disclose it with other people. And also, as people leave your company, extend, again, another level of protection. What access do these people have before they leave? Shutting that access off. Again, making sure that these individuals have a contract when they're leaving, if they're an employee. Sometimes even in an independent contracting situation, you may need to have a contract in place when you end that relationship, because you want to make sure that they're not taking all the information that you shared with your company out the door with them. So the contract piece at the beginning and the end is extremely important. I want to focus today on the area of intellectual property, and I'll do most of my focus on the area of trademark. So first thing I think is good to make sure people know, there are 4 areas of intellectual property. You have your patents, you have trademarks, you have trade secrets, and you have copyrights. That's those 4 areas. Oftentimes, people are absolutely, positively confused between what each one of them are. So I'll have people to tell me they need a trademark and they really need a copyright. They call me, I need a patent, and they don't even have anything to fall in any area of intellectual property because it's just in their mind and they haven't done anything with it. So people are always talking about protecting my ideas. And the reality is, if you have not taken time to get those ideas and memorialize them in some type of writing, some type of recording, Some, put it on paper, type it out, like really giving it some thought to it. No one can protect what's in your head. And so when people say, I want to protect this idea and you're not really doing anything with it, you have to have something that someone can see that needs to be protected. And so I want to encourage people to really think through their visions, think through their business strategies, think through your invention, your level of creativity, and then take the steps of taking that information out your mind and record it. And so one thing that I would say, often is that God want to take the thoughts in your mind and cause it to be money in your hands, right? Many of us are missing out on opportunities for multiple streams of income simply because we still have a thought that's been in our head for so many years. And through this thought, we're concerned about sharing it with people, but on the same time, we have not talked to anybody about it on how do I move forward with it. We have not talked to anyone about the steps that need to be taken. It's just still in our head. So I want you all, as you listen, to get out of that mindset is, okay, I got something in my head, I want to protect it. You have to get it down on paper. You need to be able to show somebody what that ideal is, and then you can move forward with it. So first thing to clear up. Now I want to clear up what each area is. I'll start with trade secrets because that's the area I talked about with confidentiality and non-disclosure agreements, same type of agreement, just a different name. Those trade secrets do not fall under the registration process with the federal government. That's something that is done through your business procedures and your business protocols. So if you want to make sure that there's information that people do not take, what you need to do is have a confidentiality agreement in place. Now, mind you, that particular contract is the area where I don't even want you to tell my business. So sign this agreement before I let you in my door. Like Lonnie Love was joking one time on why the name of the show just slipped my mind. The Real. And she was saying that the gentleman that she's seeing, she made her guy sign a non-disclosure agreement because her life is so public and the number of people that she's interacting with, she really does not want him to be sharing all that stuff. So think of trade secrets as being the things that you don't want people to share and you need to protect because it brings you money. I'll give you an example. If you think about Kentucky Fried Chicken, look, the 11 herbs and spices is a trade secret. Not everyone has access to the 11 herbs and spices. So that means no one else can produce it. That's how I'm protecting my business. People are known from the season of my chicken. And if you're working for me and I give you access to this information, you have to sign this confidentiality agreement. Why that is important is that you can specifically go to court relating to someone stealing your trade secret. So the money making information that you have. And so I want to encourage you all, even in your businesses and the things that you do, what are you planning to do or what are you doing that contains information you don't want other people to have because it can have an economic impact on your business. So given the KFC example, if somebody else got the 11 herbs and spices, then my seasoning for my chicken is no longer unique. And then potentially you can start getting our customers. And, so this is very important. Also, you can have something that you invent that someone want a license from you, that somebody want to do business with you. And before you enter into those conversations, you want to have your stuff protected. And so all of that falls under trade secrets. and then some with keeping things confidential. That's a major way how you protect your business. Patents are inventions. Sometimes people have thoughts, ideas about something, but they have not really taken the steps to organize those thoughts, to do something with those thoughts. And so when you have an invention and you can articulate what that invention is, and you can really spell out that invention and what it does, then that can be something that you can register as a patent. But until you think it through, you don't have anything that you can register as a patent. So it's a misunderstanding, I think, with a number of people that think, oh, I have this thought to invent something in my head. I'm going to give an attorney that thought, and then all of a sudden they're going to be able to do a patent application. Like, no, there are some details, there is some information that that attorney will need. All right. Third area. So I talked about trade secrets. I talked about patents. Let's talk about copyright. Copyright is an area that I think is garnering a lot more attention from the protection standpoint because so much is being done on social media. And many people don't really understand how much protection you have through copyright law. And it's extremely important. If you don't want people taking your content, if you don't want people stealing things out your book, then, you know, the copyright area is where you're at. Now, here's the thing when it comes to copyright. I've heard so many people talk about the poor man's copyright.
I was going to ask about that.
I had someone contact me and it was like, you know, yeah, I did the poor man's copyright. And I'm like, what? I didn't even know people did that. Like, help me understand. And when she was just so serious about it, I'm like, I have to start talking to people about this. Now, if you've never heard of the poor man's copyright, it's the procedure where, let's say you wrote a book and you want to have a recognizable copyright for your book if you need to sue someone from stealing the content from your book. The assumption with the poor man's copyright is if I mail that book to myself and then I have a date on the United States Postal Service from the delivery, that date creates a date for me to identify my copyright registration and starts my protection. That does not exist in copyright law.
Okay.
And so many people are still trying to do that. And if you have tried to do that, or if someone tell you to do that, please ignore them. Please don't try to mail something to yourself. All you're doing is wasting your time and your money because you are accomplishing nothing at all. So save your time, save your envelope, save your postage stamp, and recognize that once you have something that you created, and you have taken it from your head and begin to memorialize it through a recording, through something that you write. It can be a painting that you do. It can be a photo that you take. It can be a graphic design that you create. There's so many different things that falls in the area of creativity that comes under copyright law. And once you create it, you have a basic level of copyright protection. The issue is if you're in a situation where someone is trying to be difficult with you and you need to sue them because they're not recognizing what you're telling them you're the copyright owner. So let's say I have my book and I'm like, hey, I'm the copyright owner of this book, and you took a page out my book. Mm-hmm. People who may know this area, but like, I'm not doing nothing. Like, what are you gonna do? Yeah, I got the information. What are you gonna do? this is why I say that you cannot sue somebody for copyright infringement if you have not registered your copyright with the U.S. Copyright Office. You can't, and let me clarify that.
So that poor man's copyright doesn't mean anything.
It doesn't.
In that case.
And also, even though you can put, okay, the little C with the circle, all rights reserved, that will give you a certain level of copyright protection, but it's very limited. And again, it's going to be your word against the person word who took the information. So now you're in potentially an issue where you're paying attorneys to try to determine who has enough information that can prove that they are the actual copyright owner. Because when people steal your stuff, they're not going to do it, you know, partially. They're going to put a copyright symbol on it and their information and the date, and they're going to say, hey, I had it first. She stole it from me. You have to be prepared for people like that, because people like that exist. When you register your copyright claim, right? I have this copyright, I have this book. When you register it with the Copyright Office, what you're saying is, I want the government to recognize it. And when the government recognizes your copyright by doing that registration, then it's irrefutable, which means if you have to take somebody to court for copyright infringement, they cannot say that they're the rightful copyright owner because your copyright is already registered. I'm starting to tell people in the area of copyright, like there's a lot of people that are doing online schools, online training. People are doing master classes. They are pushing a lot of information to people. And if you're not careful, you'll give people that information and then they will turn around and use your information from your class and then create something of their own. In order to prevent that, what you need to do is consider registering your training material with the Copyright Office, registering your online class manual or content as a copyright. So then if someone tries to steal your information, you have some strong legal backing. I've had situations where there are people that I've worked with where they're in an online class, like a paid online class. This is their business. They're training people. And one of the students, or, you know, 2 or 3 of the students decide they want to take the recording from that paid master class and put it on their YouTube page or put it on their web page. Like they've downloaded your content somehow. If you're using Zoom or using these other platforms, some people have, you'd be amazed, like, you know, side cameras that can record what's happening on the screen. You know, people do all sorts of things. And so, of course, usually as long as you have a copyright statement and tell people you cannot utilize my content, you can't download it, you can't record it. That's the first step in doing what is called a cease and desist, which means I am going to send you a letter asking you to cease or stop, cease and desist, stop using my information.
So I got a question regarding the copyright. When should we do, so say I'm offering an online course and I'm so excited because I finished it. It took me weeks or months to get this done. And now I just want to get it out there. So should I wait and contact you to get it copywritten, like at least start the process? Or do I have to wait until the copywritten process is complete before I start advertising? Or what would you recommend in that case?
So it's interesting that you mentioned that, because I would say it really depends on your risk tolerance. Mm-hmm. So some people may say, hey, when I'm first starting this, you know, I just want to get it up and get it going. I'm doing a general copyright notice. I'm okay. And once I get it up and running, then I'm going to do the registration. Mm-hmm. Do that. The other issue is before you roll out the content for your online class, you can literally submit that before you even started, if that's what you, and that would have you in the process of having your copyright claim registered with the federal government before you even launched.
Okay.
Now so that's how that works. And the other thing I wanted to mention with that, even when it comes to books, screenplays, you could be writing movies, you don't have to wait until your book is published. You don't have to wait until like your movie script is published. No, once you have finalized that, you can go ahead and register it with the Copyright Office. And here's the thing to consider when it comes to things like that. So let's talk about like screenplays, movies, even sometimes book material. Sometimes that level of content can lead to other streams of revenue, other opportunities. And a lot of times you have to pitch this information to other people. You can have a pitch that you give someone for your movie script, but you can register your copyright claim in it before you do the pitch. And sometimes people don't recognize that, or even going into the pitch and say, I would be more comfortable if you signed a confidentiality agreement because I want to protect my creative idea. A number of people don't do that. And then when they go into those pitch meetings, they may not be accepted, but later on you see those same individuals doing it. And let me give you an example. The young lady from Fresh Prince, I think with Tatiana Ali, I believe that's who it was, had an issue where she claimed that she came up with the concept, The Real, the TV show, for like a multicultural panel of women. And she said that it was declined as a potential television project, but later on, as we see today, they're doing it. She tried to say, no, they stole my information when I went in and gave the pitch. They can easily say, well, we already had our minds thinking on something like this, and there was nothing that you said that we couldn't use partial or some of the information to tap into our own creativity, right? And she tried to argue it's a trade secret, it's confidential information. They should have never started the show without making her a part of it. And on the legal side, that did not work out in her favor. One of the things that she could have done was take that script, panel ideal, flesh it out like she would present it, and do a copyright claim for it. So now you have something that can be utilized to say you were the individual who used and pitched this. Okay, now I'm going to jump to trademark. After doing those three, I'm going to jump to trademark. I would say trademarks is the area I work on the most. It is the area I get the most questions about. And I will tell you, if you are doing business, you have a brand, especially if you're on social media, registering your trademarks are really important. So there are 4 levels of trademark protection: common law, state law, federal law, and then you can get into international law. Okay, now common law is as soon as you use your brand in commerce, the geographic area that you use that brand, you have a trademark right in it. So if I launch a new clothing brand in Chicago, I have common law trademark rights in it. However, I cannot stop other people in other cities of Illinois from launching the same or a similar clothing brand. And I definitely cannot stop people in other states from doing that. And the reason why is the common law unregistered trademark protection is limited to a specific geographic area where your business is.
Okay.
A lot of people who are out here that put that TM symbol by their brands, I definitely encourage people to do it. But I also want you to know that's not protecting you from someone stealing that brand and using it in another state. It is just providing public notice that you're claiming your trademark rights. And so when you see someone that has that TM next to their brand, they either are relying on common law trademark rights, so a specific geographic area where they do business, or they're relying on state law trademark rights. State law is when you take time to register your trademark with your state, so then your brand is protected on the state level. And if you want to make sure that no one else in the state do what you do using your name, then you register it with your state. But again, it will only protect you for your state. And again, why is that important? I can go on Facebook Live, even this particular online conference, we can have people on here from tons of different places. And the reality is, you can mention a brand and you have it in Illinois registered. That's not stopping someone else from New York or California or Florida from implementing that same trademark brand for the same clothing line, since that's the example I'm using, in their state. So sometimes people will say, hey, Michelle, I was doing some research and someone in this state has my business name. Or I found a couple of people that had business names that were the same or similar to mine. And so I have to tell people, because you register your business with your state, that does not mean that state business registration protects you from other people having a business name that is the same or similar as yours in different parts of the United States. Now, you can have a business that's not your brand, then trademark is not an issue. But if you have a business and your business name is your brand, so let's say in this case, you have a clothing business for your clothing brand, one of the things that you do is get that federal trademark, which is the third level. The federal trademark, when you're actually going through the process of having your brand examined, approved, and registered with the United States Patent and Trademark Office. And what do I mean by that process? Because some people, I don't think, realize this. When you put in a trademark application, you're starting a federal proceeding. It's not like run of the mill, I just fill out an application at a business and I'm done. No, you're actually starting a federal proceeding, which is why people are encouraged to get attorneys. And when you're going through that process, the federal government will look and see if someone already has a registered trademark that's the same or similar as yours. And if that's not the case, then you're able to get your brand registered as a trademark on a federal level. When you do that, your protection is national. So now other people in other states can't come after you and try to make a trademark claim. But let's say someone had registered their trademark for a clothing brand, same name as yours, in their state. What happens under that situation if you have applied for a federal trademark? That person can oppose the registration of your trademark, but they're only potentially given rights for that one state. So I have an Illinois state registration. Someone in New York does a federal application. I find out, I'm like, no, this is key to my business. Illinois, the person who did the federal application get the other 49 states.
Okay.
That's just how it works.
So it's just timeliness. So if you file it before they go file their federal application,
right,
they'll get approved for all of those states except for the one that you signed for.
Right, exactly. And it's your responsibility to watch for and monitor your brand to see if someone is trying to do something that's the same or similar as yours. And so there's a time in the trademark application process where you can actually oppose applications. So, but again, you only get the state part. Everybody else is a free for all. And the way you get that exclusive right is the federal trademark. That's what a key thing that I do with my legal practice. I help people to understand what level of protection they may get with their brand, because the reality is not every brand is a brand that can be trademarked. It can be a brand that you do business in, but it doesn't qualify for the legal standard to give you exclusive rights for that brand across the United States. So some people assume just because they have a brand name that it can be trademarked. No, if you say your brand is, you know, Crunchy Barbecue Chips by Michelle, the trademark office is going to say, Crunchy Chips, you just describing the potato chips. That's not a real brand. Get out of here. You're just describing what you do. And if you're just describing what you do and don't have something that you have established in your brand other than a description, you don't qualify for a trademark. Okay. Go ahead.
So tell me this, so I know I'm guilty of sometimes being the person that want to go it by myself and figure it out and file all the documents and do all that.
I understand.
I don't play with the legal stuff, but say you have someone that is pretty savvy and they look on the site, it seems pretty easy. What are the benefits of using an attorney versus going it alone?
I'm glad you mentioned that, because I'll talk about going at it alone and then also using a legal process service. And when I say a legal process service, think of like Trademarkia, LegalZoom, all these different platforms that say you go in here and do your trademark application. First of all, when you're using those type of platforms, you're still pretty much doing the application yourself. That's why I'm bringing this up. When you're going through those different engines, service providers, many times they are not lawyers. So when you look at the fine print, they will tell you, we cannot give you legal advice, which means we cannot tell you if you put your trademark in the right trademark class for application. We can't tell you if the evidence that you're presenting is appropriate for the trademark application. All we can do is make this information available to you and give you some general information of how to walk you through the process. But I can't let you know if you're going in the wrong direction or not. And when you're paying those different platforms, like, I would think if I'm going to take the risk, I'm just going to go in there and try to do it myself. I'm going to pay you to be on your platform to walk me through what I can do on my own. The issue with that is most times that I talk to people that have tried to do it themselves or have went through a platform, when they get the response back from the federal lawyer, they have no clue on what to do. They don't know the trademark laws. They don't know the various requirements of the images that need to be presented as proof. They don't know the various requirements for the actual name that they provide. So a number of people say, well, my trademark is A, and then they present B in a trademark application. If you don't have a lawyer to tell you those two don't match, they're going to reject it. You're going to do it anyway. And the federal lawyer is going to reject it and say, you need to give us something else. There are other issues that require a legal analysis. For example, they may say, hey, your brand is confusingly similar to someone else. And you may be looking at this like, it's not really exact. I mean, it's saying the similar, but it's not the exact thing. Well, the reality is one of the benefits of having a registered trademark on the federal level is that it don't have to be exact. All it has to do is be confusingly similar. If anything that's confusingly similar to a registered brand, that is going to be a red flag, that the application will be rejected. And so if you don't know how to do the legal analysis for those situations, then again, you're not going to know how to answer. And there are various legal prongs on different issues. If you don't know the case law, if you don't know the prongs, you don't know how to answer the questions from the federal lawyers. There are other issues, disclaimers, various things you may need to clarify, the language for your class of trademark. You will not understand those things unless you have some type of background with not just getting general information about trademark, but how do you argue and articulate the various legal issues that come up so you can be successful. Say I have a number of clients where they get to that point, and what the federal lawyer will say is, we recommend that you get an attorney. So I inherit trademarks that people tried to do themselves or that people did through a platform. That puts a limitation on the attorney that you're working with, because now I have to work with, potentially, because I don't always take on trademark applications that somebody started themselves. Some of them, for me, they're just so horrible that I don't want my legal name, my company name attached to it. It's just pretty chaotic, and it's not going to result in a good outcome for me or that person. And so when that's the case, I will decline from taking on the issues that come up in the trademark application process after you did the application. A lot of times people are picking the wrong trademark classes. They're not paying the right fees. They're not giving their proper information. I see so many things that go wrong when people do it themselves. And you can still get through some of those processes, but even when you're doing the trademark research, the way that I would do it as an attorney is going to be different from how you do it as an individual. Why is that the case? Because I know the various case law and legal issues of what could be considered similar. As an individual, most of them are looking to say, well, nothing's on here is the same as mine, so I'm good. Absolutely not. It does not mean that. There can still be other trademarks that are confusingly similar, and you need to know what the trademark law says about that in order to identify them. So what happens also, if someone does not get a lawyer to help them somewhere in the process, what happens is they don't know how to respond, so they don't respond, and then their trademark application is abandoned. They lose their money, and you still have to start over. And you recognize that you probably should have worked with a lawyer in the first place, but now you got to pay a lawyer and you have to pay this federal fee over again. So you're also losing money. I have a book that I released this year called Registered, a guide for protecting your brand, business, and bucks with trademarks. It's available on Amazon and my website, michellejmillerlaw.com. I wrote this book to help people get in a position to allow me to help them. Like, I want to inform you of why I'm asking you certain questions, why I need you sometimes make changes on your website, why I am telling you that I don't really think your brand is protectable. Understanding those different things are in my book, because I actually go through those steps. What are trademarks? Give examples. I mean, I use my law business as the example because my law business is a registered trademark. So I use even my business as an example in my book, and other popular businesses as well, so you can understand what's going on. I also walk you through the trademark application process. So if you work with me, but even if you work with another attorney, I believe in being informed about what you do. So you can have an intelligent conversation and you don't feel completely clueless, but you're giving someone your money. So the purpose of me doing this book is to give you a guide on the process. Of course, it doesn't take the place of getting your own attorney, but it will clarify some things for you. It will help you to understand some things you need to think about when building and protecting your own brand. And it'll also help you to understand the questions that your attorney, i.e. someone like me, will ask you as you get ready to protect your brand. So I would say if you want to know more, definitely pick up the book. It's $20. It'll take you through how strong your brand is on the legal trademark spectrum and how you begin to take the steps to protect your brand. Last thing I want to mention with brand protection, there are a number of people who have what I always consider brand portfolios. A brand portfolio is all of those branding things that point to the goods and services that you sell in the marketplace. So think of Nike. You think of Nike, the actual name, registered trademark. Their logo, the swoosh, registered trademark. Some of their slogans are registered trademarks. All of those areas, that's what's considered your trademark portfolio. Like the totality of things you use in your brand that you don't want other people to use in the marketplace. And so you have to decide, well, what's important to me? Sometimes I get questions, do I do my logo or do I just do the standard name? If someone wants to do a logo, I always ask them, are you committed to this font? Are you committed to this color? Are you committed to this design? If you are not committed to this and you want to change it, go with your standard wording. Because once you do a trademark registration application and start the process for your logo, you're specifically saying, I want my protection to be for this wording with this font, with these colors, right? I'm defining what I want my registration to be. Why is this important? Because then if you get people that have something that's confusingly similar to yours, they'll be like, well, I don't have the same colors. It's a different font. You know, you leave those doors open for people to make a legal argument. So I always say, if you're going to do a logo, be committed to it. And even if you're not committed to the color, be committed to the design, because you can always say, I'm not seeking, an exclusive right or claiming any particular color, just the design. When you don't claim a particular color, font in your design or in your logo image, you're primarily saying any color I use this in, I want to be protected. Mm-hmm. So those are things that people have to consider. Same thing with slogans. I definitely say be committed to it, because then if you start changing it, you can potentially dilute your protection for your trademark. So commit to it. So 4 areas of trademark: patent, copyright, trade secrets, and trademarks. Trademarks, 4 areas of copyright protection: common law, state law, federal law. Then you have international law. If you have a global business, you're doing business in other countries. Once you get a U.S. trademark registration completed, you can use that registration to then register your trademark in other countries. The flip side is, if you are in a foreign jurisdiction and you want to have a trademark in the United States, which happens all the time, then when you're in a foreign jurisdiction, you can get a trademark, but you have to work with a U.S. attorney. So that's how I make myself available for people who are not in the United States. U.S. law recently changed and said, if you're in a foreign location, you want a U.S. trademark, you got to have a U.S. attorney. And so now, since that law changed, I can say, hey, if you in London or South Africa or wherever, I can handle your trademark registration for you because you need a US lawyer to make those things happen.
All right, so I want to open up the
About
floor
it.
for any questions that anyone may have. So if you're watching either on Facebook Live or directly via Zoom, feel free to post what your questions are so we can address those. But I do have a question regarding the trademark branding. Um, well, branding trademarks. Say you
Okay.
have a brand, and of course, as you evolve, your brand evolves. Does that require another whole trademark process, or how would you
Repeat that
compensate
for
for
me.
that? If
Repeat that for me.
if you have a business and you start
Right.
off, I know you said be committed, but you start off with one direction, and then as your company, as you evolve, your company evolves.
Right.
Brand may change a little bit. You may have different slogans or whatever. Would that be what you call the branding portfolio, just to include the rest into that portfolio, or would you have to start a whole nother trademark process?
If you change the name, the brand name, that requires that you do another trademark.
Okay.
If you add on products and services that you did not have when you did, let's say you already have a registered trademark for clothing, and then you decide, you know what, I also do workshops and conferences, and I teach people how to have a clothing business. And so now I want to do that. And I don't want anybody to do those kind of workshops and seminars and conferences in a name similar to mine, because I know my training and workshops going to be the bomb. They're going to be fire. And so I want to make sure that I protect it. In that case, because you are not doing those workshops and training and conferences before, in that situation, you still have to do another trademark application.
Okay.
And one of the key reasons for that is the feel of what's available is constantly changing. So even though you have a registered trademark covering one area, when you tap into a new area, let's say it's a month later, well, now your lawyer has to do a fresh trademark search and make sure that even a brand name that's similar to what you're already doing or have not gotten that trademark for that area before you. And that happens. So sometimes in helping people with their, trademark registration strategy, they may say, well, I speak at workshops and conferences, and this is my brand name. And I may say somebody has a brand name that's exact or very close to that. I don't have a strong legal argument that say what you're doing is different. I don't want you to spend your money on something I'm telling you that I really think is a loser. What else do you do under that brand name that you feel strong enough that you would want to register your trademark in another area? Because that's how you can strategize with not having your trademark application rejected because somebody is doing something similar. So, it goes back to your question, like, why do it myself in comparison to talking to a lawyer? So when you talk to a lawyer about this, we're going to talk through those type
of. Okay. You're still there, Michelle?
I'm here.
Okay, I thought you went.
I can't believe my video never worked. This is like never.
That's fine. As long as we can hear you. If we couldn't hear you, then that'd be the real problem. So
right.
where can we find your information? Where can we purchase your book? Do you offer any type of coaching? Do you offer any type of consultation? Where do we go to reach you?
Okay, where do you go from here? My website is michellejmillerlaw.com. So it's my name, michellejmillerlaw.com. On there, you can find my book, Registered, A Guide for Protecting Your Brand, Business, and Bucks with Trademarks. I also started my law box. I'm actually preparing for my next one. So I have a law box as well that's focused on giving you information and content to protect your business and your brand that's available for you to purchase. I ship it to you, give you electronic versions of that as well. And also, you can go onto my website and click the Ask Michelle link. You can ask me a question. I can always give you a general answer, but I will answer your question. And then I offer this free discovery call. So I'll give you 10 or 15 minutes of my time to share with me what you do, what you're thinking about, and give you some feedback and let you know if you're ready to go into the process of registering your trademark on a federal level. Sometimes I have those discovery calls with people and they have to go back to the table. I'm like, well, you're not quite ready to work with me yet. And I'll say this, even when people want to start the process of protecting their brand before they launch, if someone has a hard time articulating to me what you are about to launch, I don't even want to start the trademark protection process, because if you can't clearly articulate it to me, by the time you launch it, it may be something different than what you told me when we started to do the application. And then you'll have the protection for the area that you need. And then you'll be looking at me like I'm crazy. Like, what happened, Michelle? So if I can even determine that a person is not clear on what they're doing with their brand, if they're new and preparing to start it, if a person can't articulate it, I will say go back to the table, give a few things some additional consideration, and then come back. And then some people may just have some general questions along in the process. I'll answer those questions as well. If you want to really have like a brand analysis and go through like a strategy on what you should do and different things that you're thinking about. So sometimes I have people that say, well, I have a couple of different brand names that I'm looking at before I launch, and you know, which one is stronger, which one is not. Well, that's a consultation. And also in that process, I'll take the time to start giving you some feedback and say, well, this particular brand, you know, is not looking good because of what I see. This one is wide open. So I do offer consultations as well. So those are the various ways to follow me. You can follow my Facebook page, Michelle J. Miller. I am doing my law lunch chat live Monday, Wednesday, and Friday at 1 p.m. And that's 1 p.m. Central Standard Time. And I am addressing various legal issues and topics during those days. So people can always jump on those lives and ask questions or get information too.
Okay. All right. I have one more question.
Sure.
So about websites. Is the website protected if the name itself is protected, or do we also have to protect the website?
So with your website, your brand should be on your website. Mm-hmm. And most times when I'm doing trademark application, 99.9% of the time, I'm using content from your website.
Okay.
Because many times your website should have your brand on it, and it's an easy way where people can buy your products and services. So if you're meeting like that, now let's say, for example, because I have this come up, people have a brand and then you get to their website and it's all other kind of information, and then they go by one name for this and another name for that. Then they have a different program that they're doing. Mm-hmm. You have numerous things going on your website. Then sometimes I have to say, well, now we need to refine what you do or create space to establish the brand that you say that you have by creating, say, another web page and articulating what that brand is, offering on that web page some way to get your goods and services, and making sure that that brand name is prominent. I would say a lot of times I have people that got a lot going on with their websites, and changes to their websites are needed because I can't pull the content that I need to protect your trademark application.
Okay.
And then, of course, the actual wording on your website is protected by copyright.
Okay. So good. That's good.
Anything else?
um, I don't have anything else. I think you addressed everyone else's questions.
Great.
So,
See what people are
definitely.
thinking. And my phones are freezing. I couldn't even share, so I had to figure that out. But thank you so
That's
much
how.
for having me on and giving me this opportunity to,
Mhm.
give people information in this area and allowing me, to share and educate people on this topic. Um,
Mhm.
I truly appreciate it.
Oh, thank you for coming on because I think we need to learn how to protect our businesses and protect our trade secrets as well as our branding. We won't run into jams in the future should our businesses blow up or go from regional to national or international.
Right.
We
I
gotta
always
be
tell people
prepared for that.
think big,
Hmm.
think just where you're at, think about where you could be going. And I have had conversations with people to say, let's talk about my brand. And I would encourage them to trademark it. And sometimes they'll procrastinate and then they come back to me later and somebody has already put an application in for that trademark. And so now you're at the unregistered trademark position. So now I'm limited in what I can argue for you because that person now can get the other states. And then it's first in line, is first in time. So whoever trademark application is in first, they get the priority. So sometimes if your application is similar, the pushback is there's a pending application that's similar to yours and it may bar registration of your application.
Hmm.
That means we have to deal with that application first.
Okay.
I would encourage people, and I've seen it happen. It's not just like, okay, yeah, this could happen. Like somebody can take your conference name or your clothing brand. I have seen it happen on numerous occasions. Um, and sometimes with people who I've had conversations with and I've talked to and encouraged them to register their brand as a trademark, and they didn't make it as a priority. And in that instance, I then have to tell them if their reach is beyond their geographic area, they're taking the risk of being sued for trademark infringement because now you are infringing on the other person's trademark. And then they could potentially sue you and make you stop using
Right.
that brand name, and they can also try to get some of your profits that you got using that brand name because it officially belonged to them.
Right. So people, please don't walk in with the poor man's copyright trying to defend yourself for a trademark case.
Right.
With the unopened envelope that you mailed to yourself 10 years ago and you thought that was protecting your business. That is not true. There's no such thing as a poor man's copyright. We got to learn
Right.
how to be good stewards over our businesses and set them up
Yes.
properly so that we can build legacies. Because I mean, this is
Yes.
can clearly be one of the
Extremely important.
downfall of our businesses if we don't have it set up properly. But if you
Exactly.
want to connect with Michelle, again, go to her website, www.michellejmillerlaw.com. And
Yes.
she will be right there to assist you. You can purchase her book there. She gives more information on trademark and branding and all of that good stuff. So thank you again, Michelle, for jumping on the call.
Thank you. And
We'll
thanks
be
for being so understanding that I couldn't get this video working.
oh, no, as long as we can hear you, that's all we need. Just give me an ear. But
All
yeah,
right. Thanks so much. And I'm looking forward to the other speakers you have coming on. If I can't be on live, I'm trying to catch the replays of them because you have some great people that's going to be speaking to individuals.
you got Yanni Brown this Thursday talking about
Yes.
relationships. So that's a hot topic.
Yes. Yes. Well, I
Yes.
know it's going to, continue to be great.
Yeah. Yeah. Definitely good info. Okay, so then on that note, thank you, Michelle. Everyone else who was on Facebook Live and in Zoom, thank you and good night.
Good night.
Good one. Thank you. Bye.